Hi, I'm Jenny Walterman, and this is my presentation for Module 12 on tort law in education. First, let's address what a tort liability is. It's an actionable or civil wrong committed against one person by another that is independent of contract, and it can be intentional or unintentional, usually involving negligence. Liability is a deliberate act committed by another or acts, a group of acts involving negligence, and we will see some cases involving negligence in this presentation. So we're going to discuss Houyan versus Manhattan Beach City School District, and that involves negligent supervision. Barrett versus USD 259, and that involves gross negligence and wrongful death, is the suit that was brought there. The next one we will discuss is Golden versus Milford, and that involves a case where the lawsuit involved civil hazing, and the court discussed whether it was considered hazing or bullying, and then it also involves an element of negligent supervision there as well. And then wrongful death, negligent supervision will be discussed in Barnett versus Caldwell. And then lastly, we'll discuss Davis versus Monroe County Board of Ed, and that was a sexual harassment Title IX discussion where it actually went all the way to the Supreme Court, where a school board said that they could not be sued for an individual wrong, and we'll discuss that more during that case. Let's see, but I just want to pause for just a second and talk about qualified immunity because it comes up several times in the cases that we discuss. And so I just wanted to explain qualified immunity is a legal doctrine in the United States federal law that shields government officials, that's us as teachers, from being sued for discretionary actions performed within their official capacity. So discretionary actions performed within our normal day-to-day job description, and it exempts us from being sued unless the actions violate clearly established federal law or constitutional rights. And so I just wanted to explain what qualified immunity is so that it will help in understanding some of the rulings of the court. Now I'm going to just turn the camera off of me because I want you to be able to see the whole screen. Okay, so the first case is Houyan versus Manhattan Beach City School District. This was a case where Michael, a 10-year-old, was a student of the summer school, and he voluntarily left the school and was subsequently struck by a motorcycle and sustained serious injuries. The mother, upon arriving at the hospital, collapsed and had emotional distress response to seeing her son in that situation. And so she filed a lawsuit claiming emotional and physical injury after seeing her son's injuries, and she also sued for negligent supervision, stating that they should have been responsible for Michael. And initially the case was dismissed at the local trial court, and then on appeal, the judge determined that the district was liable for negligent supervision and said that the school has a responsibility to keep students in school and closely monitor truancy, and they have a reasonable care of duty, which, when ignored, removes immunity of responsibility by the district. So there's that qualified immunity. When you ignore your responsibility of care, then that opens you up for lawsuits. So Michael's family was awarded damages due to the negligent supervision finding, and the judge also stated that the school should have foreseen the potential for students to skip school in the summer. And I think some of the safety issues we have in schools now are much different than they were in 1974. We have more secure, locked buildings and doors. And so some of my proactive solutions here are things that are already in existence now. But the proactive would be to have a more secure entry-exit point, a single entry-exit point with cameras so that you're closely monitoring any point where a student would want to be maybe an escapee. And then also take roll after points where the students have been out of the classroom, such as recess, lunch, bathroom breaks, those sorts of things. I think the reactions, if this were to happen today in our district, would be a suspension of the teacher that was responsible to notice if the student was there or not, possible termination, and then a policy review or rewrite of the district policies or building policies to ensure that it did not happen again. For this one, I think professional ethics that are addressed is that educational professionals have a responsibility to protect students from harm and ensure that they are safe and engaged in an active learning environment. The next case, Barrett versus USD 259, that's in Wichita. This took place in 2001, and Alex, as he's known, his full name Robert Alexander Barrett. Alex was a 12th grader, showed up to first day of football practice conditioning in the summer, collapsed at the end of that practice, and then died in the hospital the next day. Coaches were offering the team several water breaks during the practice, and when Alex told several coaches that he felt ill, the coaches instructed Alex to continue drinking more water. Through the findings of the court, there was a coach's handbook that was distributed to all the coaches in the district prior to the start of football practices for that season, and heat illness was specifically discussed by the activities director when he handed out the coaches' handbooks. So Alex's mother filed a negligence and gross negligence claim against both the district and the coach, Coach Dan. And so the trial court decision initially said that qualified immunity circumstances were not applicable in this case, and that recreational use exceptions also were not applicable. And so the defendants owed a general duty of care to the student, and the standards and duties for all employees, safety of student athletes, and the heat and humidity during the practice guidelines for all coaches were distributed to district employees. So their duty of care and those policies that were ignored effectively made the qualified immunity not applicable. The appellate court determined that the trial court was correct regarding general duty of care, and so they determined recreational use exception did apply, and the plaintiff cannot recover damages for ordinary negligence, but could possibly pursue claims of gross negligence for some of the above stated situations with the coach's handbook and the heat and humidity of the day and safety measures. So in this appellate decision, they reversed and remanded the case back to the trial court for them to have proceedings on the gross negligence piece of that. So proactive measures that I would take would be to possibly have physicals and health alerts on site in maybe a plastic box or something, so that if you do have a student complaining, of not feeling well, you can look at their record and see if there's any kind of health issue that you should be aware of. In addition, I think having an athletic trainer on site and even modifying practice schedule for some of those really warm August days would be advisable. Reactions that would happen in my district if this were to happen would be suspensions while there was an internal investigation, and possibly even further clarify the policies by reviewing and rewriting to ensure there's no confusion on how to handle that situation better, rather than to just continue saying drink some more water. Professional ethics is that educational professionals have a responsibility to protect students from harm and ensure that proper safety guidelines are followed. Golden versus Milford Exempted Village School District. Okay, so this case involves a freshman basketball player, and other members of the basketball team, the freshman basketball team. This occurred in 2011. One particular freshman was attacked by several other team members, but there was one student in particular who led the attack. He was known to be an aggressive sexual behavior towards other team members, and all the team was out of the building waiting for the bus, and the student aggressor, this one that was known for aggressive behavior, targeted Golden while other team members held him down. So no adults were supervising the students while they were waiting for the bus. The district investigated upon hearing of the attack, and the victim and his parents filed a civil hazing and negligent supervision lawsuit against the student aggressor and the school district and the coach. Okay, so the trial court determined that the acts were not civil hazing based on the legal definition of that, but it could be considered bullying. School district was not held liable under civil hazing statute, so that portion of it was not upheld. And then the coach was not held liable for negligent supervision, and here's the reasons why. The court said there was no evidence that the coach acted in a reckless manner. There's no evidence that the coach behaved with willful and wanton gross negligence that would lead to a liability, and the coach uncovered qualified immunity. The coach was covered under qualified immunity provided to government employees. So there's that qualified immunity again. So in this situation, if they would have found that the coach knew that bullying was going on and that it had been going on for a while and there had been reports of it and he ignored it and allowed it to continue, then that would be a potential situation where they could have found the coach or the district responsible for the negligent supervision. However, because there was no evidence of those aspects of negligence, being reckless or allowing something to continue, he was not found responsible for the situation. So proactive measures that I would suggest would be to clarify policy on supervision and perhaps establish team teachers for that situation. If you have expanding walls, go ahead and open those up, or some sort of situation where an adult can be aware of what's going on as students are waiting for that bus. Reactive, these notes are for another slide. So my reactive would be to just evaluate the policy and review, rewrite to make sure that there's an adult with the students when they're waiting for the bus. And then the professional ethics part of that is educational professionals have a responsibility to protect students from harm, ensure they're safe, and stop active harassment and prevent future harassment or harm. Okay, Barnett versus Caldwell. So in 2018, Antoine Williams died after engaging in horseplay with another student. He fell in the classroom, and then the other student fell on top of him. And what they determined medically was that his collarbone broke and it lacerated an artery, and so essentially he bled out into his body. So Caldwell was the teacher, and she was out of the classroom when this occurred. She initially stated that she was in the room, but after an investigation, the principal found out that she was not being truthful about that, and she was not in the classroom. And there were several versions of what Caldwell was doing while she was not in the room, and eventually she settled on the fact that she was in the restroom. And so that seemed suspect to me, and lacking in ethics that it took so many versions of the truth to get to where she was. I don't know why she didn't just say initially that she was in the restroom. Caldwell did ask a neighboring teacher to listen for her class. She shared a room, an expanding folding wall with this other teacher, and asked that teacher to listen for her classroom while she was out of the room. Parents did file a wrongful death suit against Caldwell, stating that she was negligent in her supervision. A lower trial court found in favor of the teacher, of Caldwell, and the discretionary act entitling official immunity was the superseding factor that had the court finding for the teacher. The parents appealed the decision, and the appellate court heard the case based on Caldwell's official immunity claim and determined that there was no intent to injure, no evidence of malice, and Caldwell was in fact protected under official immunity. And her ministerial functions are on a case-by-case basis, which means her duty to provide care for the students and an educational environment. And those types of ministerial functions are usually determined by district handbooks and employee guidelines. And because in that particular district's teacher handbook, the instruction to supervise was not clarified or well defined, they could not find evidence of any kind of malice or wanton neglect in that situation. So proactive steps that I would take would be to certainly clarify the policy on what supervision means. And does that mean somebody's with the students all the time? You need to visually be able to see them at all times or just listen for them. Also, another proactive measure would be to establish team teaching, where perhaps you are teamed with another teacher that has a plan period when you're teaching a class, so that if you do have an emergency, you need to leave the room, you're feeling ill, whatever, you can call the team teacher who's on their plan period, and they can come and physically have eyes and be a authority presence in your classroom. That's just a thought I had. Another idea would be, if you do share rooms with another teacher and you have to step out, would be to open the expanding wall. That way you can physically see what's going on in the classroom. I think reactive, if this happened in my district, that Mrs. Caldwell would be terminated. Not just because of the fact that a student died in her classroom while she was gone, but because she was gone for almost 30 minutes, and it took several days to get to the truth, and that she was dishonest and she lied to her boss, and there's still a question about why she left the room in the first place, and that's just very unethical as far as I'm concerned. And the fact that she tried to cover it up and lie about whether she was there or not just doesn't sit well with me, and I think that would be grounds for termination. I would also suspend the other teacher, because I can't imagine that much horseplay, students falling on the ground, that other teacher didn't hear something going on and should have gotten up to investigate and been more attentive in that situation. And then again, just policy rewrite, super clarify, what's acceptable and what's not, and what supervision is. So the professional ethics in this one I put were that educational professionals have a responsibility to be honest and ethical in all matters while maintaining a safe, engaged, and active learning environment. And so for her to be gone from her classroom that long allowed an opportunity for mayhem to occur, and obviously somebody got injured to the point of death. And also, it's our responsibility to engage our students and be purposeful with the time that we have with them. Okay, so the last case, Davis versus Monroe. County Board of Education is from 1999, and Aurelia Davis filed a harassment suit on behalf of her 5th grade daughter, LaShonda Davis. The court filing alleged that the school board was negligent in preventing and ending sexual harassment from another student. The case cited Title IX rights to educational benefits, which says that every student has the right to an education, and this was violated when the district failed to control the harassment. So it thereby, affected her ability to learn in the classroom because the harassment was so extensive. The suit alleged that the school board's complacency contributed to an abusive environment where her educational rights were violated. The school board was the respondent and moved for dismissal under civil procedural rules for failure to state a claim upon which relief could be granted. What that basically means is the school board said, hey, you can't sue us, we're a board, and you need to actually sue a specific person for a specific thing, and you can't sue a school board. And the court granted the motion to dismiss at the trial court level, and it was appealed a couple of times, eventually finding its way to the Supreme Court. And the appellate court did determine that the school board can be found liable and for private damage actions. And so the Supreme Court said when schools receive federal funding and they act in deliberate indifference to known acts of harassment in programs or activities, they are liable. The court said that Title IX contains an implied private right to education. So when this right to education is denied, the school board can be held responsible. So the proactive steps I would take would be to clarify the policy on bullying and harassment, establish an ethics board to evaluate appropriate action, because when you read through this case and the fact that there was complaints about harassment to the classroom teacher, to the building administrators, and then eventually to the school board, that there was a lot of negligence going on many levels, a lot of points of failure there. So establishing an ethics board or committee to evaluate the appropriate action when a complaint is filed, so that the decision to move forward or not move forward on a complaint doesn't fall with one individual person and their perspective of a situation. I also have more about Title IX and protecting student rights, and we'll look at that on the next slide in a minute. Reactions that would happen if this occurred in my district would be to terminate the teachers who neglected the sexual harassment, possibly even the administrators. And then, like I said, this was a total failure on so many levels, and actionable for a lot of people to lose their jobs, in my opinion. And then, again, policy review, rewrite about the proper way to handle complaints about harassment, sexual harassment, taking it seriously. Professional ethics, educational professionals have a responsibility to act ethically, advocate for the protection of all students from harassment, and maintain a safe learning environment. So a 5-part harassment test was developed based on Title IX and this case with LaShonda and her sexual harassment that she experienced as a 5th grader. And the test was developed to aid in determining if liability exists. And so I just think it's really important to keep these 5 factors in mind as you're evaluating situations that may arise in your school. So the first one is the student is a member of a statutorily protected class: gender, race, disability. Second one is the peer harassment is based upon the above listed protected classes. Number 3, the harassment is severe, pervasive, and objectively offensive. Number 4, a school official with authority to address the harassment has actual knowledge of it. And number 5, the school is deliberately indifferent to the harassment. So I found that list of test questions to evaluate a harassment situation, and if the district or the teacher individually has a liability duty of care to evaluate that situation. And these are citations from the court cases that I evaluated.